excluded any actio popularis. As I mentioned at the outset, I will come back to this point at the end of my pleading. But since then, Myanmar has changed governments and councils and has modified its legal arguments. It now argues that the Gambia doesn't even have standing to invoke Myanmar's international responsibility. And why is that so? Because the Rohingyas, who are persecuted and killed by Myanmar, don't have Gambian citizenship. Yes, members of the court, you heard me right. Apparently, the Gambia cannot invoke Myanmar's responsibility and therefore would not have standing to bring the present dispute before the court because the victims of the clearance operations conducted by the Tatmadaw don't have Gambian nationality. If it weren't so tragic, I would be tempted to be ironical and remind Professor Talman that the Rohingya, that he obstinately refuses to call by their name, that the Rohingya did not have Burmese citizenship either, precisely because they had been stripped of their citizenship due to the law enacted in 1982. However, I would prefer to quote the exact words that he used on Monday. He said, and I quote, "The nationality of claims rule applies to the invocation of responsibility by both injured and non-injured states, and irrespective of whether the obligations breached is an erga omnes partes or erga omnes obligation. Under the law of state responsibility, the Gambia cannot invoke the responsibility of Myanmar for violations of the Genocide Convention with regard to individuals who are not its nationals." Madam President, it doesn't take much reflection to realize how absurd or even abject this legal theory is when applied to the Genocide Convention. If we were to follow Myanmar's reasoning, no state party to the convention would have the right to invoke the responsibility of another state party as long as the latter meticulously implements its genocidal project exclusively on its own nationals. We all know, however, that genocide generally begins within a country and that most often it targets the nationals of the genocidal state itself, a group that forms a certain ethnic, racial and religious group. Very often, as is the case with the Rohingya, the members of the group being targeted can be identified because they're deprived of the nationality of the country where they live and who persecutes them, whereas they're not the nationals of any other country. Can we seriously agree, members of the court, can we seriously agree that it is in conformity with the Convention's object and purpose to refuse in such a case that any other state has standing to invoke the responsibility of the state that is the perpetrator of genocidal violence? I would like to emphasize that the consequence of Professor Talman's theory would be not only to make it impossible to invoke the responsibility of the state committing genocide against the members of a group having its own nationality, but it would also protect a genocidal state from any similar invocation, even when this state targets members of a group having the nationality of one or several third state parties to the convention. In that case, indeed, no state party would be able to take action either, unless the victims had the nationality of one of them. Madam President, members of the court, not only is the theory that Myanmar presented on Monday absurd, abject, and completely contrary to the object and purpose of the Convention, it is also erroneous with regard to the legal principles on which it is purportedly based. What does Article 44A of the Article on International Responsibility of States say? This is the article on which Myanmar has based its arguments. It says, and I quote, "The responsibility of a state may not be invoked if the claim is not brought in accordance with any applicable rule relating to the nationality of claims." End of quote. This provision does not give any indication that there might be a nationality of claims rule which would apply, broadly speaking, to any interstate claim. No, this is not what the provision says. This provision only recalls that when the rules in terms of nationality of claims apply, the invocation of responsibility of a state by another state is subject to these rules. When paraphrasing Article 44, the commentary of the International Law Commission, to which Professor Talman in fact referred, explains that the nationality of claims rule is a general condition for the invocation of responsibility in cases when it is applicable. The Gambia argues that in the case of the Genocide Convention, such a rule is obviously not applicable. Indeed, the nationality of claims rule is not applicable because nothing in the Convention's text suggests that it would be the case, particularly because, as I just explained, it would be contrary to the object and purpose of the Convention to make claims of state parties conditional on this rule. Need I remind the Court that according to Resolution 96-1, genocide is contrary to the spirit and aims of the United Nations, that it shocks the conscience of mankind by resulting in great losses to humanity through the total or partial destruction of a national, ethnic, racial, or religious group, regardless of the nationality or absence of nationality of the members of this group. What would happen to this essential and universal ratio legis that your order indicating provisional measures recalled if Myanmar's argument were to be accepted? Myanmar has made no reference to the object and purpose of the Convention when it argued that the nationality of claims rule was applicable to it. This silence is indeed eloquent, and Myanmar's about-face on the issue that it was purportedly impossible for the Gambia to invoke its international responsibility is not only misguided, but also baseless. In Myanmar has never accepted this rule as such, and that in reality, according to Myanmar again, the court has even cast a doubt on this rule in the Bosnia versus Serbia case. And yet, since the 1951 advisory opinion, this court's jurisprudence tells us that in a convention such as the Genocide Convention, and I quote, "the contracting states do not have any interests of their own." End of quote. Myanmar is attempting to look for something in your jurisprudence that the court has excluded over 70 years ago. When it concerns the Genocide Convention, there is no question of individual legal interest, and as the advisory opinion has already indicated, common interest of contracting parties belongs to one and all. However, this in no way implies that each state party would be deprived of an interest to comply with the Convention. Quite the opposite, actually. When a state party invokes the responsibility of another state that is bound by the Convention, it does indeed have an interest in doing so. However, its interest is not specific to the state itself. Its interest, which is shared by all other parties, is the interest in making sure that the common interest of prevention and repressing genocide is fully protected. As you have emphasized in your order of January 20, and I quote, that common interest implies that the obligations in question are owed by any state party to all the other state parties to the Convention. End of quote. That is to say, to one and all. The court has inferred in paragraph 41 of its order, and I quote, that any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations, erga omnes partes, and to bring that failure to an end.
Now, Professor Talman has somewhat challenged your ruling and has invited you to reconsider it. According to him, a careful rethink would be necessary because you won't have had the benefit of an adversary debate as the court gave its ruling at the provisional measures stage. Now, it's true that Professor Talman was not the counsel of Myanmar at the time, and that the arguments which he developed were not worded of a repressive nature of its. As an applicant state, Belgium had simply restricted itself to invoking the responsibility of Senegal to a breach of a repressive nature of its obligations. Nonetheless, this 2012 judgment did clearly underscore that as regards erga omnes partes obligations, if a special interest were required, then so as to be able to make a claim concerning the succession of an alleged breach by another state's party, then in a lot of cases, no state would be in a position to make such a claim, full stop. So Myanmar is seeking precisely to obtain what the court tried to avoid by the 2012 judgment. Myanmar has also raised the question of the 2007 judgment in the Bosnia versus Serbia case to support its theory about